Greetings, this is Chapter 3, Title VII of the Civil Rights Act of 1964. This law is the foundational law for all of the civil rights laws that followed. There is one law, obviously, that was passed before that. That was the Equal Pay Act. But the Title VII of the Civil Rights Act is foundationally one of the most important laws when we think about the concept of employment law. And we're going to spend a lot of time going into some detail on this to make sure that we're clear what are the rules, what doesn't work. And this is probably the one you're most familiar with, but obviously there's some detail that we need to get into on this. So there are 9 objectives to this chapter. The first one is explaining the history leading up to the passage of the Civil Rights Act of 1964. The history leading up to the passage of this act is controversial, and it's very interesting as we think about it in the context of other laws and some of the challenges that sort of bubbled up as the law was being created. And we'll see what the impact was of how this law was passed and what impact it had on other interpretations of the law downstream. So the history is really unique, and we'll talk about that in a few moments. Number 2, giving examples of the ways that certain groups of people were treated differently before passage of the Civil Rights Act. The goal, of course, in doing this is that we're setting the stage for why this law was needed, why it was essential that Congress passed this in order to create a balance. It's important for you to recognize, if you don't recall this, that laws don't come out of a vacuum, that laws are created because people perceive that there is a wrongdoing or something that is doing a disservice to others. And given this, it is important that we understand the context of what happened and why. And so we recognize over time that the law just didn't come out of thin air, that there were some good reasons why this law was passed because of what we were seeing historically, the way that people were being treated. Number 3, discuss what is prohibited by Title VII. We can talk about, what Title VII covers and what we are not allowed to do under Title VII. Number 4, recognize who is covered by Title VII and who is not. To be clear, there are categories, there are special attention made to certain people in those categories, but largely a white male could be covered under Title VII. It's not popular and it's not common, but it does happen, and I can give you some examples of that as we get into some of this material. But it is important to know everybody's covered, although there are certain groups that get more attention than others. Number 5, state how a Title VII claim is filed and proceeds through the administrative process. So just because you think you've been discriminated against, as we've already sort of talked about, you have to make your prima facie case. And then, of course, there's a whole process that you need to go through administrative procedures. And so it is important that we recognize how that gets done to make sure that anytime you may be advising somebody as an HR director, or you may have to go through it yourself, you're able to identify what the process is and continue through that process. Learning Objective 6, determine if a Title VII claimant is able to proceed after receiving a no reasonable cause finding. So the EEOC will review your cases and they will make a determination whether or not you have a case. And so we'll talk about what are your options if the EEOC does not believe that you have a reasonable cause. Number 7, distinguish among the various types of alternative dispute resolutions used by the EEOC. The goal, of course, is we'd like to avoid lawsuits. Any organization would like to avoid a lawsuit. So there are a series of alternative dispute resolution tactics that we can use to try to resolve a disagreement and try to fix the problem before it has to go to court. Number 8, explain the post-Civil War statutes, including what each is and what it does. So the Civil War statutes that we need to be aware of. which we'll get into. And number 9, discuss what management can do to ensure compliance with Title VII. And this is where you all come in, right? As managers, as future managers, as HR professionals, what can you do to make sure your people know how to engage properly in assessing a discrimination case and to make sure that everybody's in compliance with the law? So here is the basic text of the Civil Rights Act, specifically Title VII. Of course, there are many sections to the law, but this is the one that deals with employment-based issues. So Title VII of the Civil Rights Act. Number 1, it shall be unlawful employment practice for an employer to fail or refuse to hire or discharge any individual or otherwise to discriminate against an individual with respect to his compensation, terms, conditions, or privileges of employment because of such things as the individual's race, color, religion, sex, or national origin. Now, race and color often are highly correlated. So if somebody is black, they're also going to have a dark tone. But there are, even in dark toned skin, brown skin, there's different gradations of light versus dark. So of course, there may be issues of discrimination going on because of someone's color, someone's race, someone's national origin. So they try to be very inclusive of all the different variations and ways of thinking about it. The second part of this is it's unlawful to limit, segregate, or classify employees or applicants for employment in any way which would deprive or tend to deprive any individual of employment opportunities or otherwise adversely affect his status as an employee because of such individual's race, color, religion, sex, or national origin. And that is the proper citation for the law. And obviously there were some amendments done to it. So back in the olden days, as I will say, I was born in 1963, so I was born during this time. This is an example of a 1961 employment wand ad. And I remember seeing ads like this when I was a kid. Even though Title VII passed in 1964, I was born in 63. There were still ads that were set up as, trying to hire a woman, trying to hire a man, being very specific about whether or not you wanted to hire someone who was male or female. I don't recall seeing differences in terms of race, someone who's colored or not, but I do remember seeing differences in ads for women and what they were looking for in ads for men. So let's talk a little bit about the history of the Title VII. Specifically, this was a historic act that was meant to focus primarily on race. Originally, sex was not supposed to be included in the law. It was only supposed to be about race and religion in those general broad categories. And this sort of culminated the centuries-long struggle for equality that happened after the Civil War and when slavery was found to be illegal, the Emancipation, as you remember, Emancipation Proclamation, and then, of course, Juneteenth, which was related to when the blacks in southern Texas, in Galveston specifically, were told 2 years after the Emancipation Proclamation that they were free and that they no longer were considered slaves. So even though slavery was abolished during the Emancipation Proclamation, the end of the Civil War, there were still Jim Crow laws. There was specific, like de jure versus de facto segregation. Like there was obvious segregation, and then there was stuff that was just assumed, right? You just didn't do something because, things were, there was stuff for the colored and stuff for the whites, and it was very separate that way. So after the World War II, we started to see integrated military and things like that, little by little moving towards that. And so this became a huge push for more civil rights through the 50s and 60s. As 50s, we got rid of segregated education. We had integration. We wanted to see, we didn't want to have separate but equal schools because they weren't really equal. They actually were poorer in many respects. The title VII is very specific to employment, and that's really what the purpose of our discussion is going to be for this class. However, you should be aware that this act covers other things besides employment. It covers housing discrimination and educational discrimination and public accommodations, as well as federal funds. And we're not allowed to use race, color, gender, national origin, or religion in making that determination. Title VII was specifically John Kennedy's drive. He drove this intensely. And unfortunately, he died at the end of 63, November 63, when he was assassinated, but it was driven finally to passage by Lyndon Baines Johnson, who was the president after John F. Kennedy. And the focus, of course, was making sure that that this passed. It was the legacy that John Kennedy wanted to leave behind, is making sure that there was, civil rights legislation. Now, recall, we're going to get into this in a little bit later on in the semester, talking about this issue of sex discrimination. And as I've already said, sex discrimination wasn't supposed to be a part of this act. As you can see, its primary focus was race, and included religion, and sex was added, or gender, was added later in the legislation. And again, the issue here was, why would we add this? And it was actually added because the person who wanted to see it added wanted to see the legislation fail. He was from the South. He did not like the idea of Jim Crow going away, and he liked to have things very separate. And, there was, whites would be in one group area and blacks in another, and he wanted to keep that segregation. So he decided to add sex or gender as a way of undermining the law. And in fact, it passed. Despite that. So it's sort of an interesting little tidbit as you learn and understand a little bit of the history about why the act passed. To know why sex was added at the last minute. And that, of course, made it very challenging for the administrative agencies to be able to manage the discussion of what is considered to be sex discrimination. And as we get into the concept of sex discrimination and sexual harassment, we'll get into a little bit more detail about some of the challenges that evolved because sex got added at the last possible minute in this specific act. So as we said, Title VII is the employment section of the Act, and it prohibits discrimination based on race, color, gender, or sex. You may hear that terminology, religion, and national origin. I like to use sex over gender because gender is more fluid, and it doesn't quite cover biologically what the initial intent was. The initial intent was biological sex, right, versus gender and gender identity issues. But as we see, as you look further down the slide, in 2000, the 2020 Bostock decision adds gender identity or transgender protections, and that was sort of part of 2012, and then sexual orientation in 2015. So the EEOC regs had already started to cover transgender and sexual orientation, but the Supreme Court did not uphold that until 2020. So it doesn't matter what the regulations say. Organizations are still going to discriminate until the Supreme Court lays down the law and says, no, being transgender and issues of gender identity and sexual orientation are protected. And the Supreme Court, as we've said already in some of the previous chapters already, that they are the final ruling on what is protected and what is not protected. And it was surprising that it actually passed because it was a conservative court when it passed in 2020. And the court has only gotten more conservative with some of the recent appointees to the court. But it was still sort of surprising and good to see that the Bostock decision was passed despite having a relatively conservative Supreme Court. And so when we're thinking then about the employment section of the Act, the employment discrimination, what it's applying to is hiring, discharging or firing, or laying people off, compensation-related issues to some extent, terms and conditions and privileges of employment, and it forbids segregation, and it wants to make sure we don't have unequal opportunities for people. The goal of this legislation is to have equal opportunity for everybody. And it has some basic assumptions in it, which, as we talk about this relative to affirmative action, you'll see how those ideas actually work really well together. Now, there are some states that have passed similar laws with broader coverage than was covered under the Title VII. They have to minimally adhere to Title VII, and then the state laws can offer broader areas of coverage if they want to. State laws only govern conduct of smaller firms that federal law may not reach. So they actually may shrink the size of the organization that, in terms of whether or not they are protected, whether or not the employees are protected under state laws for anti-discrimination. So it is important to know at the federal level what the requirements are, but also at the state level, because there are many states where a smaller company may still be obligated to do EEO law and EEO protections under Title VII.